The defendants simply said that, after a litany of objections, a boilerplate objections, they said defendant will not be producing these trade secrets at the time, calling it trade secrets. And so I think, there's a misinterpretation of what the rules require production wise. And we're just here to ask the court to direct defendants to produce all relevant non-privileged documents related to this case.
So before we get into specifics, tell me, Mr. Lowenthal, in what way the confidentiality agreement was meant to help bridge this gap, and whether it has. It's a relatively new creature in this case. And so is it partly the situation that now that it's in place, Mr. Walraven is working to get responsive documents that would be protected, or has it not changed anything from your perspective?
Yeah, Your Honor, we when we sent our good faith letter initially, we took the time to put together a confidentiality agreement to address defendants' concerns over the objections, confidentiality related objections in the defendant's responses to our discovery demands. And, we appreciate Mr. Walraven going through and executing the confidentiality agreement. But, since executing that, following our letter to the court, we have received no indication that defendants will be producing any documents, confidentially, any documents that are alleged to be confidential or otherwise. So, at this point, we have received no indication that the confidentiality agreement will move and progress this case along.
Okay. Well, Mr. Walraven, before we dive into a few of the specifics, and I'll share with both sides my view of how we'd sort this out, is that we would, as a group, go through a few of the places where the two sides are at loggerheads, so that I could hear specifically, here's why plaintiff thinks this is relevant and disclosable, et cetera. And I could hear directly from Mr. Walraven why he disagrees. And once I get a flavor of that, I'll be in a better position to work through the remaining ones. And ultimately, what I may need to do is interrogatory by interrogatory or request by request, indicate, defense, you have to hand these over. If they need to be pursuant to the confidentiality agreement, or it needs to be upgraded to a protective order, so be it. We'll do that. But I also might respond that this is overbroad, and it may be, and I'm making this up right now because we haven't dived into it, that plaintiff says we want everything from 2010 onward. And it's clear after we discussed that you really only need it for the last year. And so I might say the defendants do have to produce it, but only for calendar year 2019. Or it could be, I don't see how that's relevant at all, given what the issue is here. But I'll need to let you have a back and forth over a couple of these so that I can get a better sense than just the dry paper that's there. But before we do that, Mr. Walraven, is there anything writ large that you want to share about the discovery dispute and what's going on here?
Yes, Judge. First, I'd like to, I hate to do this, and I'm trying to try to do it efficiently, but I would like to spend a minute or two just running through chronologically all of the work that the defendants have done in this case in response to defendants' requests and demands. They say in both the letter and on this call today that the first discovery they served was January 31. That's not true. They served first request for admissions along with the complaint, the motion for an emergency hearing, the brief in support thereof, and nearly 100 pages of exhibits, all at the same time. So discovery was served before we even knew that there was an emergency hearing scheduled. Okay, so we got that on the 13th of December. I shut down my law practice and my lobbying company right before Christmas and hyper-focused on this case so that I could come to court and try to keep these folks from shutting down my client's company. And at the end of that hearing, I recall you thanking us for being so well prepared, and that made me feel pretty good about our efforts. And at that moment, I went back home, went back to the inbox, tidied everything up before Christmas, and went home to Augusta with my kid and hung out for Christmas. The day after Christmas, you issued the ruling denying their motion. Felt pretty good, sent it to the client. I was on leave from really to the day after New Year's Eve, to January 2nd. Came back to prepare to get ready for the legislative session, which is a blistering week of events and client meetings and contract signings. And I came home instead to a motion for reconsideration. The motion for reconsideration was so ill-advised that I had to stop what I was doing in all of those other areas to produce a written document for the court, because we hadn't had time. We had to make a choice in the emergency hearing. Are we going to produce a written document, or are we going to get ready for the hearing? So that was the choice I was given. So while they're complaining about how late I've been about all this stuff, that emergency motion, reconsideration motion rather, really, it set me behind, because I'm one lawyer with two clients. They're two lawyers with one client. I had to produce two responses to their answers and answer that discovery they keep forgetting to tell you about. And we did that. Then we go into the legislative session. It's my busiest time of the year, and these guys were just buzzing around my head constantly wanting to know when this discovery is going to be produced. And I asked them, I said, I read Judge McBurney's standing order. Is it possible for y'all not to serve me with any more discovery, since I just answered all this, just went to an emergency hearing, just answered the motion for reconsideration? They wrote me back, said, no, we're going to proceed in accordance with OCGA, whatever. So they went ahead and filed first demands, their second round of first demands, on January 31. The month of February, I worked my tail off at both the Capitol and on this case. I didn't turn everything in perfectly on time. I got sick as a dog on February 29th. I coached my kids' Little League team, and we had a Friday night practice in the cold rain, and both of us woke up that Sunday sick. It took me out. And I had a bill on the floor of the State House that week, and I didn't get to go to work. And that'd be the equivalent of Mr. Siegel showing up to court on the 19th and not having Mr. Lowenthal there. It was a really big deal. So and then we get to the pandemic thing. I bring my kid home who's got severe allergies and a weakened immune system. I brought him home on March 11th. And I'm a single father. I have a lobbying company in the middle of session. I've got a law practice that's got a lot of work to do. And now I've got a kid at home every day sitting on my computer, because once those teachers figured out they could get on YouTube and teach with this, he ate up my workstation half the day. And it was tough. And so I keep getting these letters and requests and long emails from these guys, and I've turned things over. And then I really just am given short shrift on this. And I served them finally with discovery in April. 24 hours after they received discovery, I get this friendly phone call from Mr. Lowenthal. Hey, old buddy, old pal, why don't we just stay discovery because of cost? This stuff's getting expensive. And so I made him an offer. I was like, okay, why don't y'all just not do the request for productions, and y'all can answer the interrogatories and the admissions. And the response was it was a non-starter. And so they sent me another email. When are your answers coming to our 24-page 6.4B letter? And I'm like, okay, I'm getting to it. We're in the middle of a pandemic. You gave me this letter after the emergency, but you're acting like there's no emergency, and I got to just absolutely hut to. And so we get through the month of May, and they send me an email, and they tell me that if I don't have them a complete response to their 24-page letter by Memorial Day at 5 o'clock, that they're calling you. And, it was Memorial Day weekend. My son's birthday was that Saturday. And I wrote them back. And I said, guys, I'm not going to grind away on a file all weekend long under a judicial emergency and produce answers to this long letter. And they said, oh, we're sorry that we asked you to do that on Memorial Day. That was a mistake. You get another day. You can turn it in on Tuesday. So it's just been like that, Judge. And I wrote a 23-page single-space response to the 6.4B letter. And they're giving it really short shrift. It was a long letter. I put specific objections. I heard their objections in their 6.4B. I hear your comments about those answers. And for most of those discovery responses, I went back and I did put meat on the bone. I did answer why things were oppressive. I did, for instance, all sales and accounting. I think that's pretty overbroad. If they want us to go run a report and generate a new document that will show them, how much money Steve made in cleaning an apartment for somebody, just tell me to give you that, and we can talk about it that way. But, but the confidentiality agreement is in place now, and they told you I turned over one document. Well, I turned over 24 pages of single-space answers, and they had you a 5-paragraph diatribe about how bad it was within 2 hours. It took me 20 hours to write that letter, and within an hour and a half, they had already digested the whole thing and written you a letter about how bad it was, and that is just unacceptable. They're not giving me a shot. So I've got more stuff to turn over. But Judge, they want to play. They keep writing you these things that they would just want me to play by the rules. Well, the thing is, they want me to respond to the 6.4B letter that was submitted after the judicial emergency, like there is no judicial emergency. But with their discovery, they want to take 2.5 months, and I haven't said a word in complaining about it. This has been a really, really tough go. And they want 2 sets of rules. They want to play by island time when it comes to what they do, and they want me to jump whenever they say jump, even if it's Memorial Day weekend and when my son's having a birthday, and I'm done with it. So I'm working to produce more. I've got a flash drive here that the client gave me yesterday with every single text message that he's ever sent anybody from his business that I've spent time reviewing and I'm about to turn over. And Judge, the last thing I'll say is they are accusing, the plaintiffs are accusing the defendants of threatened misappropriation. That's the count. Threatened misappropriation of trade secrets. And so in their discovery, they say, give me all your trade secrets. And I just think it arrives at a nonsensical result. My client, by virtue of living and breathing and having been exposed, 3 years ago almost 2 years ago, to all of these so-called trade secrets and confidential information, he's kind of like an asymptomatic carrier of this virus. He's walking around just threatening the misappropriation of it every day. And their response is, put my client in the exact same place. And I think it's a little bit absurd. However, I'm willing to make the client produce records for all of these apartment complexes and how much work he's done, if that's what you want us to do. And it just seems, Judge, that, 1 minute they're like, hey, for costs, let's just forget this whole discovery thing and go to mediation. And then, but you look back at the history of this case, and costs were the last thing that were ever contemplated. We wrote these folks a letter in September, and the response I got was a phone call in December asking me if I would accept service. And ever since then, they've taken every opportunity to file and refile and ask for consideration. And here we are on the phone. My email back to them in that 112 pages worth of attachments was, which is it? Are we going to stay discovery, or do you want me to hurry up and let's get the judge involved and just make it more expensive? And they said that response was a non-starter. So here we are. I'm ready to produce these text messages. If they want to put their client in the position of being threatened misappropriation of all of my client's trade secrets, and that's what we're going to do, then the confidentiality agreement's in place. It just seems like to me, they have me on a merry-go-round, and they've got their feet up, and they're waiting on island time until it's time to respond to my discovery. But they got you on the phone today trying to tell you that I'm just so non-compliant, and it's just not true.
Okay,
I'm gonna leave it at that.
I appreciate that background. So you have propounded discovery requests to plaintiff. When ballpark did you do those?
Twice. I did it in late April, once on the 24th, I think, once on the 28th. The phone call from Mr. Lowenthal came in less than 24 hours after I gave them discovery. It was on the 29th. So they saw my discovery request, the first of, not the admissions, just the production and the interrogatories, and they were ready to just, go to mediation and call it quits for costs. And now they tell me the 6.4B letter is so due that you guys got to work on Memorial Day weekend for it, but ours isn't going to be due.
I've heard that, but I'm trying to understand the timeline. So you propounded discovery in late April. We're now in mid-June. Have you received any discovery from the plaintiff?
No, and I'm not complaining about it either.
Okay.
Your Honor, this is
not. You've chosen, just well within your right, not to create a stink about it. But as of now, you've received no discovery from plaintiff.
Nothing, and they're on island time, Judge. They're going to do it when they're ready.
So, Mr.
Your Honor,
Longo, since we have everyone together, why would it be that we should spend a lot of time talking about the defense partially producing discovery when plaintiff has produced no discovery? And I appreciate that Mr. Walraven hasn't brought it until 5 minutes ago to the court's attention, but now it is before me that we've got the plaintiff within their rights saying we're entitled to more than we've received. Why
I believe
the plaintiff spent some time getting materials to defend it?
Your Honor, I believe Mr. Siegel was going to respond to that.
yeah, Your Honor, we play by the rules. We don't provide boilerplate objections. And what Mr. Walraven would have had us do is to respond to his discovery, which we would have, by the way, it was subject to the emergency order. The discovery was propounded during when the emergency order was in. So the 30 days don't even begin to run until June 12th. But that aside, Your Honor, Mr. Walraven would have had us respond within 30 days of when he served, and we would have provided thorough, adequate responses without boilerplate objections. He would have had us do that before he responded to our discovery. His boilerplate objections and requiring a 30-page good faith letter basically amounts to him not having provided any response to our discovery. So we served our discovery months before he did, and he would have had us respond, which we would have done in accordance with your standing order, in accordance with the Georgia Civil Practice Act, while he hadn't responded. Discovery was served 3 months earlier. And again, the emergency order says the discovery period doesn't even begin to run until June 12th, given when he served his discovery.
Okay.
I also want to note, Your Honor, we're the victim here. There is undisputed facts that this gentleman that Mr. Walraven has represented has breached his agreement. We're after documents that speak to the liability and the damages. The documents, requests, and the interrogatories, they all speak for themselves. Mr. Walraven generalizes as if we threw some blanket request out there. The requests speak for themselves. They were very narrowly tailored to specific properties that they admit they solicited in violation with the terms of the agreement. The time period is limited to post-employment. So the requests speak for themselves, and I take strong exception to Mr. Walraven generalizing.
Okay, well, it is clear that the two sides see this differently. I appreciate that. We're not going to go back and forth on that any further. So we do have that wild card. I had forgotten about that, of the emergency order from the Chief Justice, which certainly changes the landscape somewhat fundamentally. I believe under the current order, the one that expires at the end of the week, I am able to restart clocks. Certainly that hasn't happened in this case, so yet. So when Mr. Walraven propounded discovery in late April, it is a correct application of the Chief Justice's order to say, got it, but we don't need to do anything with this until the state of affairs is changed by the Chief Justice, which he did. The subsequent order empowered the trial court, so it pushed authority back down to reinstate some deadlines, to include discovery. I haven't done that in this case because we hadn't had a conversation. I didn't issue some blanket standing order across all cases. but we're beginning to do that now. We're sending out notices to parties who have filed complaints but have not yet served. They've got 30 days. That clock is running again, at least in my division. So it's helpful for me to be reminded that clocks that would otherwise naturally start running didn't do so because of the public emergency, the judicial emergency. Mr. Lowenthal, the discovery requests that we're working through today were propounded before the March onset of the judicial emergency. Is that correct?
That's correct, Your Honor. They were first emailed and served on January 31st, and the 30-day deadline was the beginning of March, before the emergent judicial order was in place.
Okay. All right. So we do need to work through those. We'll also need to set some clear deadlines for plaintiffs' responses to defendants' requests, because that clock, as of today, and our discussion, will start running again. It's important that we keep moving this case along. I guess a silver lining for Mr. Walraven is that the legislative session has slowed down, and I suspect that when it starts up again, it won't have a whole lot to do with issues outside of how do we possibly salvage the economy. But we'll work
Judge,
to
can I
that.
speak to that real quick? Sorry, can I speak to that real quick?
Which thing?
The General Assembly.
Okay, you can.
I'll be
You
30
need to
seconds.
understand, you're not a legislator. If you're a legislator, I have to get hands off. If part of the work you do is linked to the legislative session, that's your portfolio of work. It doesn't necessarily mean that the judges who have your cases are going to agree to a stay in proceedings while you focus on your other line of work. But I am happy to hear from you.
I'm not asking for that.
Okay.
I mean, the idea that the General Assembly, quote unquote, shut down, yeah, it did, but state government didn't. And half of my client base is in the healthcare arena. I represent the largest.
Well, that would be a busy area.
Yeah, I mean, the health system melted down in March. I have the largest burn hospital in the country as a client, and they couldn't get approvals for surgeries that are contractually required. I have been doing everything from trying to help lawyers at Blue Cross to try to figure out a way to make up for the lack of half of their workforce, and at the same time calling nursing homes in Albany and trying to find somebody to go pick up their client and take them to dialysis. I mean, this has not been a vacation. It's been a lot of work. And I've had a third grader sitting here, trying to push him through reading assignments at the same time. This has not been tea and crumpets at any stretch. And the General Assembly goes back in next week, and I've got legislation in the Senate that I'd like to see fixed. And like you said, we've got a 14% hole coming in budgets, and it's going to be full court press. And that's why I asked to take leave from the 15th to the 17th, is so I could go back downtown and try to salvage what's left of this last 11 days of session. So I'm trying not to pour mouth too bad, but I don't have my feet up. I'll leave it at that.
So let's talk about a couple of examples.
Your Honor.
Yes.
Hi, this is Ben Lowenthal for the point. Do you mind if I jump in? I might be able to come to a resolution before we really work through all of these discovery demands. And
sure.
I
never say no to that idea.
Yeah. So, we have been, after you issued the scheduling order back in February, on, a couple days after, I believe it was February 24th, we first reached out to Mr. Walraven to discuss mediation. We were looking to resolve this. And since that time, we have been reaching out, trying to say, look, we want to mediate this. Can we schedule mediation? Every response that we received from Mr. Walraven was like, no, I don't want to schedule at this time. And then the whole COVID-19 issue came out, and we've been trying to bend over our backs to say, look, we will agree to mediation on your terms, virtually, with the mediator that Mr. Walraven first brought to the table. And we said, yes, we will agree to that. We need to schedule something. And then at this time, Mr. Walraven has, as far as we know, still has not agreed to mediate. And we had reached out to him and say, look, we are willing to stay discovery if we can schedule a mediation to get this resolved. And Mr. Walraven's response is, no, I do not want to have mediation with my client not in the room. At that point, we proceeded to try to move along discovery, and that's where we find ourselves right now. So if we can schedule a mediation to get this thing resolved, we are more than happy to do that. But at this time, as far as we know, Mr. Walraven's position is that he still will not agree to mediate or even schedule a mediation date.
Well, conveniently, he's on this call, so we'll hear from him in a minute. But you said something that surprises me and confuses me a little bit. Was it, Mr. Lowenthal, your client's requirement or condition of mediation that Mr. Walraven's client not be present for mediation? Because I heard you say Mr. Walraven's objection, which struck me as not out of bounds, was, well, I'm not interested in mediating if I can't have my client sitting there with me, which is—
Your Honor, that was, and I'll let Mr. Walraven address that. That was his last response. Well, I believe his last response when we asked for scheduling a mediation virtually on his terms with the mediator that he had originally brought up.
Well, but then this may be a finer distinction than I thought. I want to be real clear. It is not plaintiff's demand that if there's mediation, Mr. Juergens has to stay out of it, that only counsel can be present. That's not any demand you've put.
Not at all, Your Honor.
Okay.
We are willing to work.
Tell us in a minute, was saying, I need to have my client physically next to me. I don't like this, we're on different panels on a screen. So Mr. Walraven, I'm not going to compel mediation given the tenor of the litigation from the very beginning, but I'll certainly encourage it. Why would you be opposed to, and I ask because I'm curious, not because it would be a bad answer that you're going to give, but why would you be opposed to the outcome of today's conversation being a new scheduling order, a revised scheduling order that has as its first deadline a deadline to mediate this case? And we can talk about what a reasonable date is. It wouldn't be in the next 2 weeks. You've helped me understand that you may be busy down under the Gold Dome, but it also won't be 6 months from now. And then if and only if mediation fails, do we circle back to the discovery issues that would then be confronting us?
Judge, first, this is again sort of, what I'm learning about. They want to play by a different set of rules. They want me to play by the rules.
But I just want to know your answer, not their rules.
Here it is.
Your
here
rules.
It is. The last line of their 6.4B letter, Judge, is we will require this information prior to any mediation of this dispute. They don't want to go to mediation until they've got all their discovery, and here it is in writing. But they want to drop discovery. Hey, old buddy, old pal, let's just drop all this discovery. It's expensive, and we'll just do a mediation. And they're acting like I'm being a stick in the mud, and I won't do it. But they're asking for mediation in the middle of a state of emergency where we were all terrified that we were all walking around as an asymptomatic carrier, and the governor has a stay-at-home order in place. So, yeah, it was kind of tough to schedule mediation.
Okay, but here we are now. I'll tell you that I have cases that are going to mediation all the time. My friends who are mediators are very busy, so mediation is happening. I guess the 6.4 letter is not what I have in front of me. I have the letter that Mr. Lowenthal addressed to me, not to you, because it doesn't say anything about mediation. But regardless of the 6.4 letter, I just heard Mr. Lowenthal say, what if we just get in front of a mediator, call a timeout on the discovery situation, and see if we can sort the case out. So my very
Right.
narrow
I mean,
question to you is not
right.
what was life like a
you know,
month
because
ago?
I'm sorry. Let you finish.
Are you open to
I'm sorry about
mediating?
that.
And if so,
Yes, we asked you to actually, it was us that asked you to order mediation in this case. When we asked you to order mediation in this case, we agreed to do it in the month of May. That was before anybody had heard of coronavirus.
sure.
And everything has been pushed back in every other item of work that I'm working on, except when they decided they didn't want to respond to discovery. Now they're all about mediation. We want mediation, but they refuse to go to mediation unless they get all the discovery. And but they want us to go to mediation before they answer discovery. So they want everything from us and to mediate while giving us nothing.
Okay.
So how fair is
that
that?
would be, I could understand why that would seem problematic to you, but you and I heard something different. I heard Mr. Lowenthal say, look, let's just stop the discovery discussion. We will forestall for now our pursuit of more complete answers to discovery. In other words, we'll back away from the 6.4 temporarily, and let's go to mediation. So I'm just trying to understand, if I issue a revised scheduling order and it says discovery is stayed until the case is mediated. And so it would be, we just freeze it right now. That may mean you don't have anything. And that may be a reason for you to say, well, no, I don't want to mediate under those conditions. But you, Mr. Walraven, would not need to produce anything more to plaintiff between now and mediation. That's what I heard Mr. Lowenthal say. It would be freeze things right now, get us to mediation. Only if that fails do we then have the rest of today's conversation, but we would have it in July at some point. But before you answer, Mr. Walraven, did I accurately capture the essence of your offer, Mr. Lowenthal?
Your Honor, yes. And,
Great. I
we
just
have
want
been,
one word. Yes, it is. Super.
yes.
So, Mr. Walraven, does that work for you? Or, and I'm not fussing about this, is your point, instead of answering, yeah, that's fine, is, well, no, because I would like to have some discovery. Mediation will be more productive if they could provide, and you could tell me these 6 things that I asked for. You may be ready for this mediation now. It seems like you were back in the day when we were doing the scheduling order. So I don't know what's changed other than the things you shared with me, where you felt like you've had to work particularly hard to respond to them, and you're frustrated that they haven't responded to you. And I hear that, but my focus is, could this case now go to mediation, or has the posture shifted such that you need some discovery before it goes to mediation?
I believe, in the spirit of playing by the same set of rules, that the 20 hours that I put into a 23-page single-space response to the 6.4B shows that I am still actively producing responses and answers that, they look at for an hour and write you a 5-paragraph letter about. So, I mean, I made them an offer to just respond to the admissions and the interrogatories, and that was called a non-starter. They don't want to do discovery. Now they want to go to mediation. It's almost like this thing is flipped. So, I mean, they refuse to go to mediation unless I produce discovery. And now they've changed that after I've produced the discovery, Judge. That's the thing. But they're not sitting there with 6.4B.
Part of the issue is you haven't produced all the discovery. I heard you say today,
well,
you've got some more to hand over, and it sounds like that wasn't made readily available until the heat got turned up. But you've produced some things. You haven't produced everything. I think we can agree on that. There's more to be produced. And what I heard Mr. Lowenthal say is just stop. Don't produce anymore. Let's table the discovery dispute and go to mediation. And all I want to know from you is, does that work for you? Or instead, would you like us, I'm happy to do it. It's my job. Would you like us to work through the discovery situation, which has 2 pieces? One is the set of concerns that Mr. Lowenthal has raised that we're going to talk about today. And the other piece is turning on the clock for plaintiffs, so they're obligated within a certain window to get you what you've asked for. I'm happy to do either way. If mediation is where you're going to end up and you don't need more discovery to get there, that seems like the logical next step. But if you now see this as something where you need some discovery from plaintiff in order to make mediation meaningful, then I get that. And we should stop talking about mediation and we should start working through the concerns that Mr. Lowenthal raised in his letter to me. I'm happy to do either one. We don't need to keep going around in circles with, they have a different set of rules and I wrote a 22-page single-space letter. I heard all that. I've now heard it twice and I get it. But we need to do one of two things: talk about discovery or set a mediation date. And I am neutral as between the two.
Can we do both? Because they don't want to respond to discovery and go to mediation, and I've responded to discovery, and you know, it's not the same. We're not on the same playing level.
So
I
when
need
you
them
say
to
both,
respond.
what I had envisioned was issuing a revised scheduling order that has mediation as the next stop, and neither side has to do any more work on discovery between now and the mediation. So
I would be open to that if I hadn't spent all the time responding and re-responding throughout this whole case, and they've literally done no work on discovery production, Judge. Like, if they do a little bit, like I asked of them, then I would think if I had the interrogatories and the admissions, I don't have to get them to produce documents right now. But
okay.
They don't want to do that.
Well,
so that's where I am.
What they want to do and not want to do. This is what they're required to do. And I have actually not heard Mr. Lowenthal say he's not going to produce responses to the interrogatories. He simply said,
you're right.
But they said, look, these were provided to us at a time when these clocks weren't running. There was no clock running when you provided them. It was perfectly appropriate for you to propound discovery in April. No prohibition against that. But there also was no requirement that in any time frame they be responded to. I'm changing that today. I will enter a scheduling order that says you've got X days, and we'll talk about it, to respond to X, Y, and Z. And it may be that everyone agrees that, I'm making this part up, your interrogatories were basic enough that I could say you get 20 days to do that. I'm going to truncate the 30-day window. But I also heard you say that we would defer the request for production until after mediation. So there may be a nuanced way to put together a scheduling order, but what we're not going to do, despite the fact that you feel there's been an imbalance in work done on the discovery side, is have a scheduling order that says, all right, plaintiffs, you provide these things between now and mediation, but we're going to ignore the concerns that plaintiffs raised in their letter to me. The only reason why we're talking today is because plaintiff raised concerns. I can't not address those if we're going to keep discovery churning along before mediation.
Okay.
So what I heard you say,
get a little
back,
sorry.
and you tell me if I got this wrong. Defendant's perspective is that mediation is appropriate, but it sounds to me more like it's an equitable argument you're making, but I don't care the basis for it. Before mediation, Mr. Walraven, you would like to see some discovery coming from plaintiffs. And so you'll be able to articulate in a little bit what pieces those are, and I'll hear from Mr. Lowenthal or Mr. Siegel, a reasonable deadline for them that would be 30 days or less, optimally less, to comply with those pieces of your discovery request. That would take care of your concern. Then we would need to turn to the discovery concerns that Mr. Lowenthal raised, and I'd ask him to view it through the same lens, which is between now and mediation, which of these is the real hot button one or ones that we ought to work through so that before mediation, plaintiff has the pieces that they feel are missing. And I'm happy to do that. That's more streamlined than going through everything, but it's a little different from what plaintiff asked for. Plaintiff said, let's just table all discovery concerns. I'm understanding you, Mr. Walraven, saying, that just doesn't seem right because they've got something. You say it's a whole lot. I've got nothing. So I can understand that, but it takes two to mediate. So if I just need to know what you want to have happen before mediation so I can bake that into the order.
My request of them when they wanted to stay discovery was to answer the admissions and the interrogatories and they didn't have to ask their client to go to the trouble of producing a bunch of documents, and that was deemed a non-starter. That's kind of where I am, because the letter that you received from the plaintiffs came before my 23-page response that I keep harkening back to, which was digested in an hour and deemed inefficient, and it got short shrift. That's it. I want them to, and I haven't been complaining about it. I get it that it came in during the judicial emergency, but their 6.4 letter came in April during the judicial emergency too. So they want responses like it came, back before the order. So
Okay.
it
So
has us on a different set of times. I mean, so if they would respond to some discovery,
would be to have plaintiff respond to your request for admission and your interrogatories before we mediate. Mr. Lowenthal, or Mr. Siegel, how much time do you think it would take your team to respond to the request for admissions and the interrogatories, knowing that the clock starts today?
Your Honor, we can reasonably respond to them within, I guess the 30-day time period or maybe even 20. We need to work with our client on that. But, what Mr. Walraven had, what the terms for the stay in discovery was that, and this is a couple weeks ago when we were talking about, let's please mediate, let's stay discovery, let's mediate. And the response to that was that I'll agree to stay discovery, but you need to respond to the admissions and the interrogatories. And, that's just simply a non-starter because that does not move along the case here. We've been.
So I hear you. You guys disagree on that. I'm mapping out the order that I'm going to enter that will guide everyone forward. And I guess what I'm going to ask you to do, it's not fair to make you commit to a specific number that's less than 30 days. But I'm going to ask you, Mr. Lowenthal, to confer with Mr. Siegel and your client as to what is the quickest but reasonable date by which you could respond to defendants' requests for admissions and interrogatories. And if it's 30 days, it's 30 days. I'm not going to truncate that. I'd like to, but I don't have a sense of how expansive those are. And by respond to, of course, I mean good faith responses, no boilerplate objections. But that's going to be due out number one from our call, is that you'll confer and then you'll let Ms. Niles and Mr. Walraven know. We can do it in, I'm picking a number, 20 days, whatever it is. You'll let us know. And that will help drive what this scheduling order looks like.
Your Honor, I could tell you, I mean, for the interrogatories and the request to admit, 20 days will be sufficient. I do want to reiterate again, though, we're still waiting on Mr. Walraven's responses to our discovery. He asserts we're playing under different rules.
Yeah,
we are under different rules. Yeah, we are under different rules. I mean,
all right,
okay.
You don't need to reiterate that. In fact, I don't want to hear again about a 23-page letter or it's a non-starter. Let's just stay real focused on my questions. I've been listening carefully to what both sides have been saying. So plaintiff is saying 20 days to respond to requests for admissions and interrogatories. So in theory, mediation could occur soon thereafter. How much time, Mr. Walraven, would you want to digest what you get before you have to mediate?
I would like to go to mediation after school starts back for my kid. That would be August 2nd. They've had these discovery. If they get 20 days from here, that would be 2.5 months to respond. They'll be able to do that, and then we'll get 20 days would be July 1st. Can we just have the month of July, and then we can schedule a mediation for after August 2nd?
Sure, but if I'll hear from plaintiff in a minute, but assume for a moment that we agree. What I want is a deadline for mediation. So what I'd probably do is say you have to mediate by the end of August. That would give you dates that are after August 2. You may know more than I know about school. I have little kids as well. are you confident that your son is going back indoors, brick and mortar school, or are you going to be homeschooling him again?
Judge, I hope to God he's going back in.
Okay. Same. No, same. I have a fourth grader, and my ability to do work is constrained by the need to keep him from climbing up the walls. But I will say this: if plaintiffs agree, let's call the month of August the month in which we'll mediate, then I'm not going to require them to respond in 20 days. I'll simply say in the scheduling order that I get out that the discovery clock starts today. They may get it to you in 20 days. It may be 30, but they'll have all 30 in which to do it, because it just, I think that's a more natural way to do it. If people were going to be mediating ASAP, meaning, well, once I get this stuff, let's line up the mediator and try to do it by mid-July, I'd keep them to the 20 days. But I think it's just cleaner for the scheduling order to make clear that any discovery that was served during the judicial emergency is due 30 days from the entry of my order, which will be today or tomorrow. And then there'll be a mediation deadline of, if I look at August 28th, and that will sort out the defense concerns. Let me pivot back to Mr. Lowenthal. First, Mr. Lowenthal or Mr. Siegel, any issue with setting the mediation deadline at August 28th?
Your Honor, as Mr. Walraven said, we talked about mediation at, in February. And I just don't see why we have to drag our feet here to sit down to mediate on Mr. Walraven's terms, virtually with the mediator that he suggested. And,
so
the underlying.
I'm not requiring which mediator, but, you two sides will sort out who the mediator is. And if you can't, then you come to me and I'll pick a mediator. But the terms of the mediation are negotiated between the parties. The only term I'm imposing is you need to mediate by August 28th or you violated a court order, and we'll go from there. If plaintiff can convince defendants to mediate earlier, that's great. I'm happy to set an earlier deadline. Mr. Walraven simply said after August 2. Maybe I should say, well, then do it by the 21st. I just was trying to build in time because if there's a hallmark of this case, it's that the two sides have trouble agreeing on things. I just wanted to build in more time. I appreciate plaintiff's perspective that time is of the essence, and sooner is better. So if I were to push up the deadline to August 14th, that's 2 weeks worth of dates that you could be settling on now for the mediation that would occur after Mr. Walraven contends he'll be in a better position to adequately represent his client.
I understand, Your Honor.
Okay. I'll move it up then. Second question for plaintiff. You'll be providing the request for admission and the interrogatories. You'll now have the full 30 days. You provide them when you provide them. Are there particular items from the universe of discovery you've requested for which there is an active dispute that we were going to cover today? Are there particular items that you would still like us to talk about because they are higher priority than others, such that I could include them in the order that I issue? It says this needs to be complied with as well. We're not able to dodge the whole thing. I appreciate your offer, Mr. Lowenthal, which would be table discovery. Let's just go to mediation. But it takes two to tango, and there was only one dancer on that one. Mr. Walraven understandably wants some discovery, and I appreciate that he is taking some of it off the table. Don't worry about the request for production. We'll circle back to those if mediation doesn't work. So I'm asking you, in that same frame of mind, are there specific things in your list of concerns that prompted your May 28th letter to me that we ought to talk about today so that if I'm going to dislodge them from Mr. Walraven, I include that in the order.
Thank you, Your Honor. I was just talking to myself on mute. There's a laundry list of demands that we're requesting. I think to get to the very heart and to not, take the time to really work through each one, there are, I will go through the ones that we really see as just, vital to both parties here to understand the allegations of this. And I think we can go to our request for the RFP number 8, requesting all documents pertaining to or any way relating to sales or other accounting related documents
All right,
of
hold on.
turnkey services.
Your interrogatories came first, so I have to scroll through all that. All right, RFP 8, which is page 4 of your request for production. Am I looking at the right thing?
You are, Your Honor.
Okay. All right.
And
So
this would,
start talking about 8. It's in front of me now. Thank you.
Yeah, so we're looking to see the the sales documents, the documents related to the actual sales of turnkey customers that were also customers of AGC, which would be the competing customers between July 13, 2016 and present. So we looked at 2 years prior to the Mr. Gergen's termination. And, if the court sees that, we're willing to even go to the date of termination, which would be July 13, 2018 to present. We had concerns that there might be competition while Mr. Gergens was employed by plaintiff. So that's why we did the 2 years prior. We're not saying every customer, saying only turnkey customers that were also customers of AGC from July 13th, 2016 to present. We see this as relevant and gets to the heart of the issues in this matter. And Mr. Walraven has said that he will not be providing these documents, and we would request that the court tell him that he should produce these documents.
Okay. Mr. Walraven, I figured we would focus on 8. This does seem to be at the heart of things. The scope doesn't seem, well, you tell me what your objection is. I'm reading some of it here. Let me just process it. All right. So fortunately, I don't see you saying this is irrelevant. Tell me your concern about responding to RFP 8.
In our response to the 6.4 letter that we sent on the last week of May, what I explained was, in my opinion, the words sales and accounting, you put those two together, and I think it covers every single document that defendant has created in the ordinary course of doing any work for anybody. Accounting.
So I'm sorry to interrupt, because we're in new areas here, and I
please do
hear what you have to say. But wouldn't that be the whole point? Because it's limited to these overlapping customers. So it would be overbroad if it was, give me anything you've ever done in relation to sales or accounting for any customer. It's not what this says. It is focused appropriately and relevantly to overlapping customers. And it strikes me that any documents your clients have relating to overlapping customers would go to the heart of the matter. They may not end up being particularly helpful for plaintiff, but they seem to me as being eminently discoverable. So that's where the disconnect started with me. It's not any customer, it's that narrow universe of overlapping customers. If AGC worked there and your client worked there, that's what we're talking about.
Okay. Well, first I would say that it requires my client, specifically Steve Jurgens, to have actual knowledge of who AGC has been doing business with for the last 23 months while he wasn't in-house, because they're asking for everything to present. And so the question itself, if AGC got a new customer 4 months after Steve Jurgens stopped working there, this question asks him to know who they are. That's impossible. The second part,
I don't know that it's impossible. From my recollection of the hearing, it's a somewhat tightly knit community, but you raise a great point. It still would be speculative, and that's not the way this ought to work. I see a fix, and I'll talk to Mr. Lowenthal about it in a minute, but keep going.
And we really, this is these guys clean apartments. The gist of this thing is, he gets a phone call from somebody. They do most of this stuff over text, which my client's been working hard to produce this stuff. I'm about to hand it over. But the only way for me to come up with a document that captures what they're requesting is to create one. And if the court wants us to create a document that would, basically essentially go ask him to run a report, if there is such a thing, on how much revenue that the company produced from working with an apartment complex, we'll do that. And now that we have the confidentiality agreement in place, we'll do that, because the idea that one party can possess this information and be in threatened misappropriation of confidentiality, and the other party then can say, hey, we want you to give us the same stuff. It just seems kind of nonsensical, but I will ask him to produce that kind of information. Quite candidly, Judge, I think the right spot here is to go produce that information for.
You still there? Mr. Walraven? Mr. Lowenthal?
Your Honor, I am still here.
Good. No, it showed that you were muted. I want to make sure. I don't know what happened with Mr. Walraven.
Yeah.
Let me see. Nope. Mr. Walraven, you may want to call. If you can hear me, you may want to dial back in. Mr. Walraven, can you hear us now? All right, don't take it personally, but I'm going to remove you, and maybe if you dial in, it'll work better. Well, you may not be able to come back if I do that, so I won't do that. Mr. Lowenthal, without going into the substance of others, how many other RFPs or interrogatories did you?
Hey, sorry guys, I don't know what happened.
Oh, you're back.
I got dropped. It just says call ended, and my phone was just sitting there. But I stepped outside. My son's been kind enough to be playing outside quietly with the puppy while I've been doing this call, but I had to go bring him back in, and so I can continue now.
Okay.
I just didn't know if Zoom kicked us off because we had been on for so long or not. But
no, I have an account that can go on forever, unfortunately.
Okay.
So,
my apologies. I'm back.
That's okay. So you were indicating that your client can pull this together, but you said a better idea would be, and we were all waiting with bated
Yes.
breath. And
My thought is that, these guys have done an investigation into my client's interactions with others, and they have alleged and brought witnesses, and it seems like they know where their laser is focused. And if I think it's possible to produce numbers pertaining to sales for all of the apartment complexes where the allegations were made. But it would have to be us creating that. These things don't exist. And so, but it does, like you say, get to the heart of matter. I mean, I'm paying attention, but we're going to be handing over, definitely the same trade secrets that they accused my client of being in threatened misappropriation of. So we needed some protection.
okay.
And now we have it.
So Mr. Lowenthal, as to RFP 8, I think it is on point. I think the time frame is fine. Are you in a position to provide the list of customers? It's hard to respond to if, well, let me put it this way. It could promote or provoke more back and forth if AGC believes that Juergens knows that apartment complex X is an AGC company, and he actually doesn't know that. It's requiring him to speculate in part. And as I mentioned, I gathered from the witnesses who testified, it's not such a huge universe that it's a mystery who's doing work where, but we'll get more certainty and avoid more conflict if AGC could provide the list of customers for which it is seeking information. Does that make sense?
Your Honor, it does. And I haven't talked to AJC specifically about it, but we will talk to them after this call, and we can, following discussion with them, we can provide a list.
Okay. And you don't necessarily need to say these are our customer. We just want to know if you've been doing business with, well, they need to, the way this is framed is that these are also customers of AGC. And I think it's appropriate. It does go to the basic thrust of the complaint. All right, that's RFP 8. What else?
Your Honor, and also, I started with the RFPs. There's a corresponding interrogatory to that. It's interrogatory number 10. And I would request that the defendants also provide the information with 10, which is listing those customers, and then also the amount those customers paid defendants for their turnkey services. And I think we can go off the same list that we can provide.
Got it. So it's the corresponding interrogatory, but in order for Mr. Walraven to target his responses and not worry that he'll get accused of omitting something, for RFP 8 and interrogatory 10, AGC will provide the list of customers it has in mind of these are ours, and we want to know, were they also yours? Okay, got it. All right, what's next?
All right, and Your Honor, I think, there are so many different responses there, that we could, go over at this point. I think, we stand by being ready to go forward with mediation, and want to. And I think,
so if you got the responses, well, you're going to get two things, because I've heard Mr. Walraven now mention several times he's got this thumb drive that he's itching to hand over to you. So you're going to get that. But then you will also get, per my order, subsequent to your provision of the customer list, you will get responses to interrogatory 10 and RFP 8. So if you get what you've already received, the thumb drive, and then responses to RFP 8, interrogatory 10, you're good to go until mediation. If mediation crashes and burns, you're not waiving anything. We will reconvene, and if we need to thrash through the remainder of these, we'll do it. That's part of what I need to do if there's a disagreement. But what I'm hearing you say is what you have plus what you'll get, meaning thumb drive, RFP 8, interrogatory 10, gets plaintiff in a position where it is comfortable entering into mediation that will occur by August 14th.
That's correct, Your Honor. And, like you just said, if mediation doesn't prove fruitful, we can, we would seek other responses to our demands. But, at present, we get
We'll pick
these.
this discussion up.
Yeah.
So, Mr. Walraven, to I think close the loop, assuming you get within 30 days of today responses to all your requests for admission and all your interrogatories, then you'll have what you would like to have before entering into mediation that will be complete by August 14th. You similarly aren't waiving your right to have your request for production responded to. We're simply agreeing to table those with the hopes that mediation resolves the matter. If it doesn't, then just like plaintiff will be in a position to renew its concerns about what they felt were incomplete or inadequate responses from defendants, you'll be in a position to say, now about those requests for production. Does that format work for the defendants?
Yes.
All right. Mr. Lowenthal or Mr. Siegel, anything else? Well, before I ask that question, the confidentiality agreement that's been entered into, both sides understand that's nothing I've signed. It's just something, I guess, that the parties have agreed to be governed by. Is that correct, Mr. Lowenthal?
That is correct.
Mr. Walraven?
Yeah, they drafted it. We signed it.
Okay, great. I'm glad you guys were able to accomplish that. So, given those parameters we've been talking about, Mr. Lowenthal or Mr. Siegel, anything else for now on behalf of your client?
The only last thing, and we don't object by any means to Mr. Walraven's notice for leave of absence. We just request that Mr. Walraven provide the reasons for the leaves of absence per the rules. That's all. We don't object to any request for leave, but we just ask that Mr. Walraven provide the reasons for that leave per the rules.
Okay. Any reason, Mr. Walraven, the rule shouldn't apply to your request for leave? I'm not particularly curious as to why you're going to be gone, but the rules do say it's personal vacation, it's continuing legal education, legislative session. Any reason why you can't revise that?
No, sure, I'll do it.
Great. All right. Mr. Walraven, anything else on behalf of your clients at this time?
No, thank you.
So here's the plan. I will enter this revised scheduling order. If anything in it is different from what you think we talked about, please reach out to Ms. Niles so that we can fix it right away. August 14th, in my mind, is still pretty far away, but it's not forever away. And I want to make sure that if there are hiccups or road bumps between now and that deadline, you bring them to my attention so that we can smooth them over to make sure that you are able to have a meaningful mediation opportunity. If it's going to work, that's great. If it's not, then after the mediation doesn't work out, you need to let Ms. Niles know that we should reconvene and set some other deadlines. Does that work for you, Mr. Lowenthal?
That does, Your Honor. Thank you for working with us through all this.
All right, Mr. Walraven, anything else? Uh-oh, he may have gone outside again. Mr. Walraven, you still there? Well, I'm going to assume all is well with him. He can reach out to Ms. Niles if there's an issue. I appreciate everyone dialing in and enjoy the rest of your week.
Thank you, Your Honor.
Bye.
Thank you, Your Honor.